Thank you very much. It's a great pleasure to be here at University of Virginia, where Thomas Jefferson, who framed the first one to introduce the term nullification in political discourse, was. Does an American state have a constitutional right to nullify within its borders an act of the central government judged by it to be unconstitutional? It does, according to the theory of the Constitution put forth by Thomas Jefferson in the Kentucky Resolutions of 1798 and 1799, and by James Madison in the Virginia Resolutions of 98 and the Virginia Report of 1800. The Constitution, they said, is a compact between sovereign states, creating a central government as their agent to which are delegated only enumerated powers. All other powers are reserved to the states. Now, the Supremacy Clause in the U.S. Constitution says that all acts of the central government in pursuance of the Constitution are the supreme law of the land. From this, it follows that an act of the central government not in accord with the Constitution is null, void, and of no force, not a law at all. Now, who has the final say over whether an act of the central government is constitutional? Many today would say the Supreme Court, but that cannot be true. The Supreme Court is an agency of the central government created by the constitutional compact between the states, and so is a party to the dispute. It would contradict the idea of a compact to say that an agency created by a compact and given only limited powers has the final authority to define to the principals what the limits of those powers are. It follows from this that a state has, as Madison said, a, quote, duty to interpose and protect its citizens from lawless actions by the central government. And Jefferson used the term nullification being the, quote, proper remedy, end quote, proper remedy. These came to be known as the Principles of 98. Now, there are a few confusions about nullification that need to be removed. First, nullification is not an act of revolution or even civil disobedience, whereby a valid law is violated to uphold a moral principle. State nullification is a lawful constitutional act whereby a competent authority, a sovereign state, which is a party to the constitutional compact, declares an act unconstitutional and refuses to enforce it. In this respect, it is comparable to the President vetoing a bill judged to be unconstitutional, or the Supreme Court declaring an act of Congress or state legislature unconstitutional, or for that matter, of a jury refusing to convict a person under a law it judges to be unconstitutional. So it's not as if we don't have nullification. Second, since nullification raises a constitutional issue, it might seem to require 3/4 of the states, the number required for ratifying an amendment, but no such majority is required for it to have authority. The nullifying state is not trying to amend the Constitution in the face of a valid law it finds repugnant. It is declaring that act not to be a valid law at all. Now, the point of nullification is to protect the citizens of a state from having their reserved powers usurped by the central government. To that end, only a few states, or perhaps only one, might be sufficient to cause the central government to rethink and back off, especially if the other states do not object to its interposition. But what if one or a minority of states nullify and the others declare the central government's action to be constitutional? One possibility would be a constitutional amendment, in which case the state would have to comply if it wished to stay in the Union. The other possibility would be that the nullifying state would be tolerated and allowed by the other states to remain in the Union and to enjoy the power in question within its borders. Now, this might seem unreasonable or even unjust, but it is not. Recall that the state enters the Union as a sovereign political society. A sovereign state is one that can govern itself without the permission of other states unless through a compact it has expressly delegated certain powers to an agency. What powers does the Constitution say the central government has? They are nothing more than the powers delegated to it by the states. What powers do the states have? They are indefinite and undefined because they are the powers of sovereign states. Since the Constitution does not and cannot specify what they are, the Supreme Court cannot have the final authority to define them. Only the states can do that. To illustrate how nullification might work, suppose the Supreme Court extends Roe versus Wade to include a right to infanticide within the first week after birth. Now, this is not far-fetched, since there is no moral difference between infanticide and partial birth abortions, an act which is well within the moral horizon of many of our cultural elites, political elites. Now, suppose only one state in the Union refuses to allow infanticide on the ground that prohibiting it was never a power surrendered to the central government. Would it be unreasonable or unjust to allow this one state to remain in the Union while enjoying a power other states have willingly surrendered? No, it wouldn't, because that is just what the Canadian Constitution allows. Any Canadian province, through what is called the Notwithstanding Clause, can nullify a federal law within its borders in the area of civil rights, notwithstanding that other provinces allow it to be enforced. Any federal system, to look at the thing in a philosophical way, that is serious about preserving the self-government of its federative political societies must allow some form of corporate resistance to usurpations by a central authority. Such resistance, of course, can take many legal forms. New England states have the longest and most insistent track record on state nullification. The embargoes of Jefferson and Madison, the War of 1812, conscription, annexation of Texas, fugitive slave laws, all were nullified by New England state legislatures, judges, juries, townships, and even a convention of states held at Hartford. John C. Calhoun, however, argued that the only authority that could really nullify a state would have to be a convention of the a law would be a convention of the people of the state. A judge or a legislature is not sufficient. That's a very high bar. So we can argue about how nullification should be written in law. Now, every school child is told that our liberty is preserved by a system of checks and balances between the three branches of the federal government. But nothing is said about the check the people of the several states have to the federal government through state nullification. It is assumed the people have a sufficient check to unconstitutional acts of the central government through national elections and constitutional amendments. But this simply hasn't worked. For example, the Constitution does not give the central government authority to involve itself in education, abortion, school prayer, marriage, health care, law enforcement, and 100 other things. When Nancy Pelosi was asked, where in the Constitution does Congress have the power to coerce individuals to buy health insurance, she laughed. As well she might. Congress, the imperial presidency, and the Supreme Court can pretty much define the limits of their powers. So in addition to the horizontal checks we have at the central government level, there should be a vertical check reaching down to the sovereign people of the states themselves, and it was this vertical check that the principles of 98 sought to articulate. Canada has such a vertical check with this notwithstanding clause, and Americans have explored a variety of ways the states can protect their citizens from federal tyranny. For example, Madison's original draft of Article 5 placed the amendment process in the state legislatures. If 2/3 of the state legislatures concurred on an amendment, there had to be a constitutional vote. This was defeated in favor of the absurd system we now have, in which 2/3 of the states can petition Congress to call a constitutional convention, in which amendments can be proposed, which means that Congress would pretty much set the agenda. And in the Confederate Constitution, only 3 state legislatures were needed to propose an amendment, and 2/3 were needed to ratify. So that's another example. William Watkins recently has proposed another kind of instance of the Principles of 98, which he calls a constitutional commission containing commissioners from each state. And it would work as follows. A state legislature selects 2 candidates from its members to be voted on by the people of the state to represent them constitutionally in the commission. When the chair of the Constitutional Commission receives petitions from 1/5 of the state legislatures requesting a ruling on the constitutionality of an act of the central government, the commission will convene, and if 3/4 of the commissioners vote against it, it is null, void, and of no force. The way we do it now is Supreme Court does it. Votes are 5-4 sometimes. But can't the people amend the Constitution? Yes, but not through the state legislatures. Congress is effectively the gatekeeper. Since 1790, over 10,000 amendments have been proposed to Congress. Only 30 have left the gate, and 27 have passed. It is practically impossible for an amendment to pass Congress that would limit its power. And even if passed, the Supreme Court could interpret it through construction in different ways. So neither by national elections nor by constitutional amendments do the American people exercise any meaningful vertical check on tyranny in the central government. Some check did exist when state legislators elected senators, but that was abolished by the 17th Amendment. So without a revival of the principles of '98 in some form or other, and we can argue about the form, go all the way from Canada to the other examples, talk of self-government in the United States is simply that, just talk. Thank you.
Thank you. Professor Guelzo.
I'm grateful for the opportunity to be here at UVA, the other institution of higher learning in this country whose colors are orange and blue. Gettysburg likes to think that we have a copyright on that, but I'm here to admit that I have discovered otherwise. I'm also glad to be able to be part of this particular debate, and particularly grateful for Professor Owen's clarification at the very beginning of the issue to which we are speaking tonight, and that is that the nullification of which we are asking the question, is nullification constitutional, is the null and void act of a state legislature of an executive or judicial or legislative action of the federal government. On that understanding, and within that definition, the answer to the question, is nullification constitutional, must be, should be, and has been no. These are the reasons why. First of all, individual states, whatever sovereignty does attach to them, lack the sovereignty to nullify federal legislation under the Constitution. The question is not whether that is a good idea or a bad idea, whether it should be or should not be, whether it has produced good or evil. That is not the question at issue. The question at issue is nullification constitutional. And under the Constitution, as per Article 6, Section 2, it is not. Article 6, Section 2 is what Professor Livingston has referred to as the Supremacy Clause. I believe that he has somewhat misstated it, so let me read it to you. The Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land. And judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. It is hard to know what it is about supreme law of the land that we don't get if we're talking about nullification. What this means, in effect, is that national acts take priority over state acts when there is conflict with national law. The only exception being when Congress limits itself and the extent of its own legislation. And this has been demonstrated, not very recently by what can be construed as outrageous acts of the national legislature, some of which, in fact, I would agree with Professor Livingston, are outrageous acts. Notwithstanding, the principle of nullification has been struck down as a solution as early as 1851 in Cooley versus Board of Wardens, which invalidated a state law based upon the Commerce Clause. And it is demonstrated most generally in McCullough versus Maryland in 1819. States, therefore, on the basis of the Supremacy Clause, lack the sovereignty to exercise nullification. Secondly, the states are forbidden expressly by the Constitution from exercising the greater prerogatives of sovereignty, and this in Article 1, Section 10. States, according to Article 1, Section 10, may not enter into treaties, alliances, confederations. They may not grant letters of marque and reprisal. They may not coin money. They may not emit bills of credit. They may not lay imposts on imports or exports. They may not maintain troops or ships of war in peace or in any circumstances except imminent danger. Now, if the states lack these greater powers of sovereignty under the Constitution, then I ask, how in the name of consistency and logical thinking can we suppose that states have a constitutional power to nullify national laws? Third, there is no provision, no mechanism for nullification described in the Constitution. And that is passing strange, because for a power so important, so vital, it is odd by its absence that there are neither criteria for determining what can and cannot be nullified, or by what process nullification ought to proceed. Fourth, nullification violates the expectations of the other states of the Union. The expectation of all the states that make up the Union is that all the states will operate in harmony with each other under national laws. But as such, nullification means that a state may act in disharmony with other states that are abiding by federal law, and thus contradicts the expectation that members of the Union have that all of them will act together. For instance, in Article 4, Section 1 of the Constitution, we read that full faith and credit is to be given to the public acts, records, and judicial proceedings of every other state. But how can full faith and credit be given by, let us say, Alabama, to an act of nullification by, let us say, Florida, unless Alabama agrees to likewise nullify the same national law? So nullification is an expectation that actually cuts against the sovereignty of the other states. It treats the other states and their sovereignty with contempt. Fifth, nullification similarly contradicts Article 4, Section 2, and the 14th Amendment by violating not merely the expectation of states that all states will act in harmony, but the expectations of individual citizens that they will be treated as citizens of the United States. After all, what does Article 4, Section 2 state? It says, citizens of the United States shall be entitled to all the privileges and immunities of citizens of the several states. Nullification wants to add to that, citizens shall be entitled to all the privileges and immunities except those which individual states may decide to interpose at any given time, at which point the notion of privileges and immunities pertaining to citizens of the United States ceases to exist.
But if a state may nullify a national privilege or a national immunity, how can it recognize that same privilege or immunity in the citizens of another state? How can we have a union? Notice also that the 14th Amendment states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. But if a state may nullify a national law, then in terms of the operation of that law, what the state has done is to seize jurisdiction over the United States citizens within its own borders, forbidding them to obey a law which, as United States citizens, they are otherwise obliged to obey, and thus opening them to the pains and penalties which are exacted by federal law for non-compliance. Do states, in the act of nullification, respect their own citizens as citizens of the United States? No more than they respect the rights and the cooperation and harmony that they are to expect from other states. Once again, nullification stands as a gesture of contempt. Sixth, nullification has been, and I cannot say this over and over again enough, nullification has been expressly struck down by, first of all, the federal courts, in such cases as Cooper versus Aaron and Abelman versus Booth. We are not talking here about some theoretical possibility when we talk about nullification. We are not even talking here about what might, under some other circumstances than the Constitution, be a desirable political arrangement. Perhaps it might be. But under the Constitution, the United States Constitution, which is the issue at debate tonight, nullification has been ruled repeatedly out of court. Not only repudiated, but in fact repudiated and denied by the federal executive. And in this case, the classic example is that of Andrew Jackson in his proclamation regarding nullification. Pardon me, but I want to read just this one statement of Jackson's. I consider then the power to annul a law of the United States assumed by one state incompatible with the existence of the Union, contradicted expressly by the letter of the Constitution, unauthorized by its spirit, and inconsistent with every principle on which it was founded, and destructive of the great object for which it is formed. No one, I think, can accuse Andrew Jackson of being a friend of centralized government. And yet, even Andrew Jackson, in the strongest possible terms imaginable, condemns nullification as a cure for disgruntlement. And that brings me to my seventh point, which is that nullification is constitutionally incoherent. Not only does it violate the letter of the Constitution, not only has it been repudiated by our constitutional history, but it is in violation of the spirit of the Constitution. It is a violation of its spirit because where the Constitution seeks to promote domestic tranquility and the general welfare, nullification promotes anarchy and discord and contempt for the rule of law. It functions in that respect like the old Polish veto. The veto which, it has to be remembered, is the mechanism by which Poland destroyed its own independence and sovereignty. It had nullification, all right, a nullification which nullified the existence of Poland. Likewise, nullification violates the principle of majority rule, and it has not operated to protect individual rights. Rather, nullification operates to protect group identities and special interests. Thirdly, nullification appeals to the spirit not of union, but of disgruntlement and of disagreement. Lastly, nullification underestimates the fragile nature of liberty itself by opposing liberty with power. The founders saw that in such a conflict, liberty always loses. Hence, I stand for the Constitution and against nullification.
Professor Livingston, you have 10 minutes to respond.
Well, I think we have a problem here with two incommensurable theories of the Constitution. The compact theory of the Constitution, which I'm defending, and the nationalist theory, which Professor Guelzo is defending. And if the nationalist theory is true, then I agree with what he said. And so the question is, which of these theories of the Constitution are you going to give your allegiance to? Now, I think Americans have inherited both of them, and so we have something of an incoherence in our constitutional tradition. Let me give you some reasons for the compact theory. That theory requires that you believe, first of all, that the states are sovereign political societies, and secondly, that the Constitution is a compact. Were they sovereign political societies? Let me see the time here. Right. Declaration of Independence, the colonies declared free and independent states with the right to do all things that states could do. In treaties with Sweden, the Netherlands, Britain, and France, the states are recognized by name as sovereign states in the treaties. In international law, Article 2 of the Articles of Confederation says, and I quote, that each state retains its freedom, sovereignty, and independence. Those are technical terms in law. A state cannot retain its sovereignty unless it had it. But and is the Constitution, that was so much for the sovereignty, but is the Constitution a compact between states? How would we know that it is? Well, we go to the most important article in the Constitution, Article 7. Why is it the most important? Because it defines what ratification is and who the authorities are that breathe life into this mere proposal. And Article 7 says that the Constitution will hold if 9 of the 13 states ratify it, and it will hold between the states, quote, so ratifying the same. So Article 7 says the Constitution is between the states, not between Americans as individuals, as Professor Guelzo's argument requires us to believe. Now, did the states lose sovereignty when they joined the Union? Some have said that. That's not possible. In international law, sovereign states cannot lose sovereignty by implication, but only by express action. And no state gave up its sovereignty in ratifying the Constitution. In fact, Virginia, if you read Kevin Gutzman's book, Virginia's American Revolution, you see clearly that the Ratification Convention of Virginia believed they were ratifying a treaty with the other states. Virginia put in her ordinance of ratification the right to secede, to withdraw the powers delegated. So did New York and so did Rhode Island. These states clearly thought that in ratifying the Constitution they had not in the slightest given up their sovereignty, though they had delegated powers. If we look at the first works on the Constitution, the very first one by St. George Tucker, 1803, he goes out of his way to make it very clear that the Constitution is a compact between states and that therefore states can withdraw from the Union if they please. Compacts between sovereign states having no stated time of duration are compacts at will. And that's what Tucker says the Constitution is. Not that one wants to secede, but that it's a right. Also impressive is William Rawle. This is one of the second most important books on the Constitution, 1825, called A View of the Constitution. Rawle raises this question: can an American state form a monarchy and an order of nobility? He says, of course it can. They're sovereign states. But if a state forms a monarchy, it has to leave the Union because Article 4 guarantees every state a republican form of government. Then his question is, how does a state leave the Union? And he lays out the legal and lawful conditions for withdrawing the powers that a sovereign state has delegated to the central government and seceding. He says this, quote, "The secession of a state from the Union depends on the will of the people of such state. The people alone, as we've already seen, hold the power to alter their constitution," end quote. Rawls' book was the text on constitutional law at West Point from 1825 to 1840. It was reviewed in the Boston's prestigious North American Review and was pronounced, quote, "a safe and reliable guide to the Constitution." John Quincy Adams, on the Jubilee of the Constitution, 1839, concludes as follows. He clearly recognizes the Constitution to be a compact. "The indissoluble link of union between the people of the several states of this confederated nation is not in the right, but in the heart. If the day should ever come when the affections of the people of these states shall be alienated from each other, when the fraternal spirit shall give way to cold indifference, or collision of interests shall fester into hatred, the bands of political association will not long hold together parties no longer attracted by the magnetism of conciliated interests and kindly sympathies. And far better will it be for the people of the disunited states to part in friendship from each other than to be held together by constraint." That's John Adams, 6th President of the United States. He couldn't say that unless he believed the Constitution was a compact. This same Adams in 1843 signed a document with other New England leaders saying that, warning that the annexation of Texas would mean the secession of the sovereign states of New England. Now, nullification was vigorously carried out in the antebellum period. Professor Guelzo has mentioned a case in which the court rules out nullification. Of course the federal court's going to rule out nullification, and so will the presidency and so will the Congress. They're agents of the central government. But nullification went on anyway. Wisconsin nullified acts of the Supreme Court in the 50s and as late as 1859, and it stuck. Medical marijuana has been outlawed by the federal government in California. The California does it anyway. It went to the Supreme Court. Supreme Court ruled against the state. Doesn't make any difference. They're doing it anyway. There are 1,000 dispensaries in Los Angeles County alone. And not only that, but other states, conservative states like Alabama, who don't like medical marijuana and don't want to have it, have come out in defense of California's right, reserved right as a sovereign state to take care of the health of its people as it sees fit. Now, let's look at the nationalist theory very briefly. That theory was defended famously by Story, Webster, Lincoln. What it holds is the American states were never sovereign. The American people in the aggregate are sovereign, and the theory goes like this. When the colonies seceded from Britain, they descended into what John Locke called a state of nature, an aggregate of individuals, because there was no law, no British law. They formed the American political society, authorized the Continental Congress as their government, and the Continental Congress authorized the formation of states. So the states are artifacts of the will of the American people. They're like counties in a state, American state. Now, if they are like counties, then they can't nullify a federal law. Just like a state, a county in a state cannot nullify a law of the legislature because it's a creature of the legislature. And a county cannot secede from a state because it's a creature of the legislature. So if the American states were like counties, then it would, Professor Guelzo would be right. And this is how Lincoln solved it. Lincoln asks incredulously, quote, "What is this particular sacredness of a state? If a state in one instance and a county in another should be equal in extent of territory and equal in numbers of people, wherein is the state any better than a county?" End quote. On the nationalist theory, you have to think of the states in that way. So the question you have to ask yourself is this: to which of these theories are you going to give your allegiance? One thing about the nationalist theory is there is no historical support in all of the public acts that created the Constitution and ratified the Bill of Rights. There is no evidence for it. The only evidence that I can see is the claim that upon seceding from England, Americans descended into a state of nature and formed a national political community that created states. But that doesn't hold, because John Locke says that a state of nature does not exist if there is a legislature. And the colonial legislatures existed. They simply transformed themselves into states. There was never a time when the American people were an aggregate needing a government. David Hume in the 1730s in Scotland wrote, and I quote, "The charter governments in America are almost completely independent of England," end quote. What the colonial governments did is they just marked out the almost part. In other words, they said, not any almost, we just are independent of England. So the nationalist theory has no historical support for it in the documents that led up to the Constitution. Every document says the Constitution is a compact, the states are sovereign, and the idea that there was one American people in the aggregate and the states are administrative units is something all nationalists maintain. But it has its origin more in the French Revolution than it does in the American Revolution.
Okay.
Forgot how much time I have.
Yes.
What?
I'm afraid that
That's it.
That's
Good.
10 minutes. You'll get another opportunity, Professor. Professor Guelzo, you have 10 minutes.
Thank you. I have to come back to the point that we articulated at the very beginning, and that is, we are asking, is nullification constitutional? We're not asking whether nullification is a possibility under the Articles of Confederation. We're not asking whether nullification is a possibility under the Canadian instrument of government. We are asking whether nullification is constitutional, the United States Constitution. And that is what we must continually come back to. And when we do, what we discover is that the preamble to the Constitution does not begin by stating, we the states, we the sovereign states, we the attempters to create a compact. No, it begins by saying, we the people, all those nasty American individuals, just getting together and saying, we're going to have a convention and we're going to write a constitution for the whole country. There's no sense in which you can talk about state nullification powers in a constitution whose preamble states as its purpose the promotion of a more perfect union, of domestic tranquility, of a general welfare. When has nullification ever promoted domestic tranquility in this country? The answer is never. It has instead led to civil war, to bloodshed. Are those the consequences that we want to visit on our heads today? Are they not, in fact, the consequences that have occurred in every movement current today, in which political factions attempt to nullify the actions of each other, to secede from each other? Is it bloodshed that we really want to write our political documents in? Is it not rather the spirit of harmony and virtue that we should be showing forth as a republic? That is what is captured in the preamble. And its enemy is nullification. We, the people. Samuel Adams, a great skeptic on the subject of the Constitution, had it exactly right when he looked at the preamble and the first three words and said, I stumble at the threshold. Well, he might, because he believed in a compact theory. But the compact theory, the word incidentally, does not occur in the Constitution. It's not the way the Constitution describes itself. Instead, what he recognized, and rightly, was that the United States Constitution was not a compact between the states. He regretted that, but he lost, because the Constitution is the act of the American people. I might add also that I think it is a misstatement to speak of the federal judiciary, the federal executive, the federal legislative, as having no say whatsoever, no valid say at least, on the legitimacy of nullification, because they are, as Professor Livingston says, agents of the central government, something which makes them sound a little bit like spies. I hear Johnny Rivers singing Secret Agent in the background. No, to the contrary, the federal judiciary, the federal legislature, and the federal executive are the agents of the Constitution. They were created by the Constitution. They exist for the Constitution. They may do things that we don't think, individually or personally, are constitutional, but there is a recourse in that case, and that recourse is not the recourse to nullification and bloodshed, but to the peaceable resolution of differences through the system of checks and balances laid out in the Constitution itself. Is it really true that no state gave up its sovereignty at the time of the Constitution? Oh, it is certainly true that some states, in their ratifying instruments, attempted to perform the equivalent of presidential signing statements by saying, we ratify the Constitution, but we reserve this, that, and the other. But as Robert Bork has written, what makes law is not intent, but the law itself. And what was ratified was a Constitution that made no such provision for nullification or any of the other reservations that the ratifying conventions of some states might think that they were imposing. Professor Livingston quotes St. George Tucker and William Rawle as an authority on the legitimacy of nullification. He is certainly right if we believe that nullification is constitutional. The question, however, tonight is not whether St. George Tucker is right. The question is not whether William Rawle is right. I can, with as much ease, cite Chief Justice Marshall or Joseph Story or even, perish the thought, Abraham Lincoln. And I can cite those with as much effect. They would also be as fully beside the point. The question is not whether nullification is the doctrine of St. George Tucker or Abraham Lincoln. The question is nullification constitutional? And it is not. Professor Livingston believes that what I am articulating is a nationalist theory of the Constitution, for which there is no evidence, that the United States seceded from Great Britain. I do not recollect ever having heard our war of 1775 to 1783 described as the War of American Secession. Why? Because it was a revolution. Why was it a revolution? Because we terminated monarchy. What we were governed as before was a monarchy under a king. Even here in the colonies, the colonial legislatures had no legal standing whatsoever and only functioned because Parliament in England did not want to take the time, trouble, or money to contradict it, which by the 1770s they decided, in fact, they did. Law was handed down in the name of the king. Justice was executed in the name of the king. What happened in our revolution? We got rid of kings, and I say good riddance to kings and everyone like them. We had a revolution. We threw out monarchy. We created something entirely different, and that was a republic. And the testimony to that fact is that we had to rewrite all of our laws concerning property. That is what happens when you have a revolution rather than a secession. We had to rewrite our codes of justice. We had to do it from the top down. And we had multiple conventions, not just a constitutional convention in 1787, but we had multiple state conventions attempting to rewrite state constitutions to bring them into harmony with the new Republican reality.
Yes, we had a revolution. We did not secede from Great Britain. I do not regret not being British. I am an American. I am not just a Pennsylvanian. I do not function just under the Pennsylvania Constitution. My flag is the flag of the United States. It is the flag under which my forebears fought, that which my son fought under for 2 tours of duty in Iraq. It is the flag by which I rise or fall as a citizen. And the one who raises his hand against that flag is my enemy. I say that frankly and fully. Now, quickly, I have some questions I would like to pose. Professor Livingston has invoked the names, the sacred names of Thomas Jefferson and James Madison. But I ask, did Madison really advocate nullification, as Professor Livingston has defined it, or at least implied? Let me read to you what Madison wrote in 1800 on the subject of nullification. The declarations of nullification in such cases are expressions of opinion, unaccompanied with any other effect than what they may produce on opinion by exciting reflection. They are not a trumping of sovereignty. That was not Madison's doctrine of nullification. Secondly, I asked Professor Livingston, how different in nature is nullification from secession? And does not the one lead ineluctably to the other? In fact, historically, has that not been the case? And have we not seen our nation drenched in blood as a result of that? Thirdly, I ask, if nullification was so critical, then why wasn't it incorporated into or described by the Constitution, by the Constitutional Convention, or by the amendments that compose the Bill of Rights? Then again, I want to ask, isn't the principal lesson to be derived from the Virginia and Kentucky resolutions, from Calhoun's exposition and address, from all other theoretical attempts to talk about nullification? Isn't the principal historical lesson to be derived from them that they lost? Get over it. They lost. Nullification is as dead as Marley's doornail. Lastly, I want to ask this question. Does not nullification make us more rather than less vulnerable to corruption, the great enemy of virtue in a republic? Because nullification, by allowing individual states to assert an illegitimate sovereignty, also makes it cheaper, easier, and less visible for those possessing great power in other spheres to corrupt political power. What I mean by that is not a state legislature more vulnerable to the overwhelming pressures and powers exerted by lobbyists, by big money, by the lure of corruption and corrupt bargains? Are not state legislatures more vulnerable to that? Precisely because if they have a power of nullification, that will draw the powers that corrupt to those locations so that they may operate with immunity there? Is this not, in fact, what we find happening with federal drug laws and the example of California? Is this not, in fact, what is happening in the case of Arizona and immigration? So, we look around us and we see not only how little purchase the notion of nullification has under the Constitution that really exists, but we also notice what evil and noxious flowers spring from those gardens that are watered by nullification.
We now enter the final round, as it were. Each of you has 5 minutes to sum up and conclude. Professor Livingston.
Well, nullification has been demonized as a noxious weed with blood and everything else. But let me point out that the principles of '98 and this is the point I want to make, has to do with that vertical check that the people of the several states have on runaway centralization of power. And that can take many forms. The Canadian Notwithstanding Act, Madison's notion of starting amendments through the legislature and so on. So nullification can take many forms. We have to keep our mind on the principles of 98. Now, the states nullified acts of the central government throughout the antebellum period, and they kept the central government within its enumerated powers. As of 1860, the federal government was nearly out of debt and imposed no inland taxes. Today, far from being free of debt, the national debt is some $13 trillion, and in addition, the U.S. has commitments, Social Security, and so on, estimated by some at $100 trillion. More debt, more spending still goes on. But the deeper problem, and this is going to change the subject a bit, the deeper problem is not centralization as such, but that the Union itself has grown too large for centralized government. And this puts the principle of nullification in a quite different light, and I want to talk about that. This year, the budget of Congress is $3.55 trillion, which, with the projected deficit, is close to $5 trillion. That's an amount equal to the entire gross national product of Germany. This money will be spent by a handful of people. How many? There are 435 representatives in the House, 100 in the Senate, and 1 president. A lawmaking majority of only 269 people. Ruling 309 million. But that is not all. By law, Congress can act with a quorum, which it usually does, and in which case a majority of both houses is only 135. A system of this kind cannot possibly represent the vast mosaic of conflicting interests spread out on a continent among 309 million people. Now, the ratio of representation to population in the House today is 1 for every 710,000 people, a ratio not within light years of self-government. What is to be done? Increase the number of representatives? No. 435 is about the right size for a lawmaking body. Look around the world. It is the Union itself that has grown too large to be governed by any centralized authority. When the first Congress met, there was 1 representative for every 60,000 people. Madison thought that was an inadequate ratio, 1 for 60,000, for a country of nearly 4 million. But if this inadequate ratio were used today, there would be over 5,000 members in the House. Wouldn't that be beautiful? A body much too large for making any laws. If the ratio we use today were in Madison's first Congress, there would be only 6 members in the House for 4 million people, nearly 4 million. Size alone has destroyed self-government in the U.S. Congress. Not corruption, scale. But worse, most of the regulations we live under are not passed by Congress, but by agencies of the imperial presidency with Orwellian names like EPA, IRS, FCC, FTC, FDA, FSEC, FDIC, on and on, not to mention the czars. But worse still, 9 unelected judges on the Supreme Court, through Alice in Wonderland interpretations of the 14th Amendment, have usurped the reserved police powers of the states to make major social policy for 309 million people. George Kennan, architect of the Cold War containment policy, fellow at the Institute for Advanced Studies at Princeton, argued that, and I have had a correspondence with him about this, that the Union has just gotten too large for self-government, scale, and that we should begin in America a public debate on how to downsize it into federations closer to the people. Now, just to give you some idea, how big is the U.S.? If it were divided into, say, 5 regional federations, say the North, South, Pacific Northwest, Midwest, and Southwest, each would have a GNP larger than France or Britain. The South, if Oklahoma were included, would have the 2nd largest in the world after Japan. California, if it were an independent state, would have the 7th largest GNP in the world. New York would be the 5th largest economy of Europe. Florida would have a GNP larger than Argentina or Australia. Texas would be larger than Brazil. I'm just giving you some idea of size and scale, something we don't talk about when we think of states being like counties. These look like countries, not counties. They're not countries, but they look like it. Now, I do not presume to know how to divide an out-of-scale union with a central government out of control. I don't know how to do it in order to restore some measure of self-government to us. But if it is to be done, the central government can have little say in the matter. The instruments of reform can only be the states themselves, calling regional conventions of states and acting in their sovereign capacity as the distinct political societies they always were, and we would see very clearly they still are. Any such reform of size and scale can only begin when the states begin prudently and gradually, through thoughtful nullification, the principles of 98, and we can argue about the form of nullification, whether it's an amendment process that starts with the state legislatures or whatever it might be, recalling those powers they have allowed, that are reserved to them under the Constitution, that they have allowed to slip out of their hands. Thanks.
Professor Guelzo, 5 minutes.
I take us back to our original question, which we seem to be wandering away from time to time. And that is nullification constitutional? I do not disagree with Professor Livingston that there are many problems in our society, many problems in our government. I do not deny that there is overreach by certain individuals, and he and I would probably even agree on the list of those individuals. He and I might even agree to what desert island we wish we could fly them. That much he and I would be thoroughly agreed upon. What we do not agree upon is the remedy. Because the remedy that he proposes is not a constitutional remedy. It is, in fact, poison to the Constitution. It is to take a cure which is worse than the disease and hope for health. I ask, if the nation is too large for centralized government, is it not, by the same logic, too large for nullification by the states? Are there problems? Sure there are problems, but is nullification the answer to the nation as it is and the Constitution as we have received it? Professor Livingston thinks that we should be smaller in terms of the scope of our government. Well, I don't know. How many people should we exile? How many people should we put on boats and send someplace else? What's the right number to get down to? I don't know how we would do that. I don't know either why the principles of 98 are necessarily sacred. They've never been enacted into federal law. They are not amendments to the Constitution. I have never yet seen American soldiers die for the defense of the principles of 98. Remember the Alamo? Yes. Remember the Maine? Sure. Remember Pearl Harbor? You got it. For the principles of 98? No, I haven't heard that, at least as far as my reading has gone. I have to ask, too, why have the basic issues that I have raised in terms of the Constitution and nullification not been addressed here? I've spoken to the matter of the Supremacy Clause, but there has been no response. I have spoken to the matter of state sovereignty and the fact that the greater prerogatives of sovereignty are expressly denied to the states, but that has not been replied to. I have asked where nullification appears in the Constitution and where the process of nullification is described, if it is, in fact, that critical a corrective, if, in fact, it is a vertical
check and balance. I think there are vertical checks and balances, by the way, but nullification is not one of them. But this particular question has not been addressed. I have asked whether nullification violates the expectations of other states of the Union. I have asked whether nullification undercuts the common citizenship of all citizens of the United States, but this has not been addressed. I have asked whether nullification can possibly be embraced when it has been so repeatedly struck down by the federal courts, by the federal executive, when in fact it is issued in a war that has drowned our nation once in blood. I have asked whether nullification is constitutionally incoherent, whether it violates not only the letter of the Constitution but its spirit. I have heard no responses to these issues. I have heard very eloquent political theory. I have heard might have beens, should have beens, would have beens, under other circumstances. I have heard complaints about problems. I have heard all these things, and I grant legitimacy to all those things, but they do not address, they have not addressed, and Professor Livingston has not addressed this question. Is nullification constitutional? Chief Justice John Marshall began in his youth as a militiaman here in Virginia. At the beginning of the Revolutionary War, he enlisted in the Continental Army. He went through the snows of Valley Forge. He came to regard George Washington as the greatest man of the age. And in later years, he said that the Revolution had taught him to think of Congress as my government and the American flag as my flag. And I think so should we all. Nullification raises an angry, petulant hand against all of that. Andrew Jackson is a young man born in 1767 in South Carolina, saw both of his brothers die on a rotting British prison hulk, and his mother die as a result of disease caught from trying to nurse them. He was captured himself, and when a British officer demanded he black his boots, and Jackson refused, the officer slashed him with his sword and left a scar that remained for the rest of his life. And it imparted to Andrew Jackson a burning hatred of all of his country's enemies, whether it be British redcoats or whether it would be South Carolina nullifiers. With whom do we stand tonight? I, for one, say that we stand with Marshall. I say that we stand with Jackson. I say that we stand as Americans. And on those terms say, is nullification constitutional? No.